Hello and welcome to the webinar titled Alternative Clauses in Buy-Sell Planning, Including Sample Language. I'm Shannon Griffin of the Society of Financial Service Professionals, and I'll be your moderator today. Today's FSP Go webinar is the result of attendee feedback from a recent program with Jim Aussem entitled Methods to Fund Buy-Sell Agreements. Along with very favorable reviews, we also received many requests for Jim to take a deeper dive into some of the topics he touched on in that program. Today, we present the first of two follow-up webinars in direct response to those requests. Jim's focus today is on the alternative clauses and sample language in buy-sell planning. And on June 22nd, we will offer a program in which Jim will address the use of insurance funding in buy-sell planning. Visit fspgo.com after this webinar if you'd like to register for the June 22nd webinar, if you have not done so already. Now, just a couple of quick housekeeping items before we get into the presentation. First, this webinar is being recorded, and you will be able to access the recording in a day or two by logging into your FSP Go account and going to the My Account tab and then Downloads. Also, we have made available a PDF copy of both the PowerPoint slides as well as a document with sample clauses that Jim provided. The document can be accessed right from within the webinar by clicking on the tab that says Handouts, and it can also be accessed in your FSP Go account. And we will save time at the end of the program for any questions you have for Jim. Just type them in the questions feature on your control panel. And now to our presenter, Jim Aussem, JD AEP. Jim is shareholder in the Cleveland law firm of Cavitch Familo Durkin Co. LPA, as well as a member of its board of directors and co-chair of the business practice group. Jim's practice is focused on succession planning, mergers and acquisitions, as well as estates and trusts. Jim is a past president of the Society of FSP and has been active in the Cleveland FSP chapter. He is a frequent speaker, facilitator, and instructor for many professional organizations on topics such as business succession, buying and selling businesses, estate planning, insurance, trusts, and estates. Jim, thanks so much for being back with us, and I'll turn it over to you.
Shannon, thanks very much. Good afternoon. I hope you get something of value from this. The last time we did this, didn't have enough time to really drill down, get into certain details, and there was a lot of requests for that. So at the risk of putting some of you to sleep, we're going to do a little bit more deeper dive today and try to give you things that would be helpful to your practice, whether you're a financial planner, insurance person, practicing attorney, CPA, or otherwise. You probably are going to encounter buy-sell agreements, and in most cases nowadays, the provisions that I'm talking about are contained within operated agreements, close corporation agreements, etc., but they certainly deal with the topic of buy-sell planning. I'm going to go through this part pretty quickly because this was covered in the last seminar, and then we're going to switch to the actual clauses, and I'll walk you through the actual clauses and when they might be useful in your particular practice. So let's deal with types of buy-sell agreements. Certainly the stock ownership redemption, and I say stock, as you recall, stock could also mean membership units of an LLC. And we virtually use LLCs exclusively now because they give you all of the benefits of a corporation, but much more flexibility in terms of asset protection planning, etc., without any real downside vis-a-vis taxes or otherwise. Cross-purchase agreement is where the members, shareholders, own life insurance policies on each other. And when the person dies, the policy is paid to the owner of the policy, who then uses the proceeds to acquire the deceased member, owner, shareholders' stock or membership units. And the hybrid method, which is also known as the wait and see, would use both concepts. The corporation, the LLC, might be the buyer, or the individual shareholders or members might be the primary buyer. They would use the insurance that they have, and then the balance would be paid through a promissory note or some other methodology. One of the things you have to understand that when you're talking about a redemption, if you will, the funding, the insurance probably needs to be owned by the entity, because the entity is the party obligated to acquire the deceased member's interest. And therefore, if it's going to use the life insurance to acquire that interest at a minimum as the down payment on an acquired interest, that it needs to own the life insurance. And certainly to the extent that the life insurance is not sufficient to pay the full purchase price at the time of someone's death, then we strongly suggest that the surviving members of the entity, whether it's a corporation or an LLC, guarantee that obligation, because the decedent's estate, trust, or otherwise, the seller is acting as a bank, if you will, if there is no payoff at death or at closing, and the balance is to be paid in a note, and that note is issued by the buyer. The buyer in this instance would be the entity. So we want the members of the entity to guarantee that. And you also have to be cognizant when you're using a redemption structure that it may impact the balance sheet of the entity. For example, if the purchase price at the time of death is $2 million and there's only $500,000 of life insurance because the person became uninsurable or otherwise, then you're going to have $1.5 million obligation of the balance sheet of your client entity that is going to be paid over the terms of that promissory note to the deceased member's estate. That could restrict the ability of the operating entity to borrow money, conduct its business in the normal course, could violate certain covenants with the lender, etc. So those kinds of issues need to be examined when you're talking about using an entity, which some people like because it's the simplest form of a buy-sell arrangement, having redemption, but not necessarily the best, most economical or advantageous form. Cross-purchase, pretty straightforward. Funding by the members. The members own the insurance policy. That's how it's done. And if the members own the policy and there are 4 members, so you have each person owning 3 policies. So you have a necessity of 12 policies because each person has to own a policy on the other ones. And certainly sometimes we use an escrow trust arrangement to avoid transfer of value and other complications associated with multiple cross-purchase arrangements. Basis step-up is achieved, however, whereas basis step-up is not available in a redemption. And then you have to address how the premiums are paid. I'm going through this fast today because most of the details regarding these kinds of issues are going to be addressed in the June 22nd seminar, where we're really going to get into funding issues, structure, and those sort of things. Today, we're going to focus more on the actual clauses in the agreement and how you might utilize them when you use one versus another one. The hybrid method is the wait and see, and you have to think through with your clients. Do you want the preference, the person, the entity, to be the first buyer, if you will? And therefore, if you want them to be the first buyer, for example, in a cross-purchase arrangement, so they get a step up in basis, that's probably where the insurance ought to be held. And to the extent that there is not sufficient insurance to fund the entire purchase, perhaps the balance then will become the obligation of the entity. A lot of various ways to do that, but the hybrid method is quite often done because the parties may not have adequate insurance. Instead of being personally obligated, they perhaps want the entity to be obligated. And the key, from my perspective, talking to this audience, is the hybrid method complicates the funding with life insurance because the insurance, you're not going to have it owned half by the individual shareholders and half by the entity. It's either going to be owned by the entity or it's going to be owned by the member shareholders, not both in my experience. The triggers in a buy-sell, and we're going to get into this at some length today because the language is necessary. Death, disability, departure, and discord, what I call the 4 Ds. And when you sit down with a client and you want to explore this kind of planning with them, feel free to use the 4 Ds because it'll help you and help the client zero in on the things they have to think through, the things you can assist them with, and the solutions that you can provide. So you start out asking your client, if you die, what do you want done with your interest in the entity? Should your estate be obligated to sell? And the response I'm going to have to you, you'll see that as we get further into the drafting language, that it should be obligated to sell. If it's not obligated to sell, then it's not binding on the Internal Revenue Service, by the way. The estate has to be obligated to sell for the buy-sell provisions to lock in the IRS vis-a-vis value. So if it's the option of the decedent's estate to sell, it's not a binding obligation. Therefore, the IRS can disregard it as well. Who is required to buy? Is it the entity or is it the surviving members? And you may use the hybrid methods, or are they given an option? And the thing that I think is important, right, and we're going to get into this as we get into the documentation, that if the estate is obligated to sell, which I think it should be, then either the entity or the members one or the other should be obligated to buy. It shouldn't be just an option to buy. In other words, the surviving members or the entity should be required to use the life insurance or whatever other funding mechanism they have, and they should be required to buy. And just giving them, quote, an option to buy, and therefore the deceased owner's estate has no one to sell their stock to, is a very, very poor result, and actually will penalize that member's family, and I think should be avoided. You'll see as we get into the language some of that issue. What if the deceased member is not insurable? Well, of course, death would still require that deceased member's interest to be purchased by either the entity or the surviving shareholders or members, and therefore it would come in the form of a promissory obligation funded through the profits of the entity going forward. And the concern always is to be practical. If your client is the hard driving, hard charging, the key person who's making this company go and making this company profitable, and they pass away and they're not insurable, is your client at significant risk because the survivors may not be as successful running that company as your client was? And the answer to that is, of course, your client's estate, your client's family will be at risk. So we talk about trying to get your clients insured as early in the process as possible, and perhaps insuring it for as much as possible, so that if they become uninsurable later on, it may not have such a significant impact. Disability. We talked about this, and we always talk about this in the context of we are significantly, from an actuarial standpoint, more likely to become disabled before reaching, quote, normal retirement age, which used to be 65, and I think that's getting pushed, than we are to die. So if you are representing an entity with multiple owners, 2, 4, 6, 8, you're likely to have somebody who's going to become disabled and will then trigger that buyout provision. So the question becomes, what constitutes sufficient disability? Could they do half of what they did in the past? How do you deal with that? And we'll talk about that a little bit when we get into the language clauses later on. Can you just insure this disability for the full amount? Perhaps. I don't sell either life insurance or disability insurance, but my recollection is on a per $1,000 basis, disability insurance may be more expensive than life insurance. But the question is, can you at least insure a portion of it, and then with the balance to be paid over time? And the question becomes, will a portion be paid through wage continuation? And then once the wage continuation continues, does it start to be applied to a stock purchase? And I will also remind you, wage continuation plans, unless they are documented in some fashion, if that person is no longer able to work, you can't pay them and deduct it as salary unless there's a formal obligation by the entity to in fact do that. And that is sometimes forgotten, and sometimes people just say after someone gets disabled, they continue to pay their salary for 6 months to a year. Well, if they're not working, that salary is not deductible. So those are dividends or something else. If you have a wage continuation plan, they would be deductible to the entity, which is obviously by far the better structure. Departure, somebody wants to be gone. They don't want to do this anymore. They're burned out. They want to go to Key West and 10 Bar. I don't know what it is, but departure means they're leaving. Now that for, should they have a put? Should they have the right to put? We'll see that as we get further into these details, to force either the entity or the other shareholders to buy them out if they want to quit? Or should there be some restrictions because they are forcing the entity to buy them out before they're ready? Certainly life insurance, particularly if the life insurance has a cash surrender value or some kind of a component, accumulated cash inside the policy, could be used to help fund some portion of the departure. And certainly life insurance could also be used as cost recovery to recover the out-of-pocket cash flow that is used to buy somebody out upon their departure. The final 4 Ds, the final one is discord. And there's a debate about discord. The concept being, should you give the parties an exit strategy? And I think you should, by the way, and we're going to talk about some exit strategies today. Or should you force them to find a way to work together to seek consensus, because there is no easy out. In other words, it's like having a prenuptial agreement that says, now, if we don't eventually stay married. We've prearranged how we're going to split up our assets and what we're going to do, and therefore it's a heck of a lot easier than trying to figure it all out later. And I submit to you that buy-sell planning, buy-sell agreements, close corporation agreements, and operating agreements are business prenuptials. The push-pull mechanism we're going to get into in some length here today, because the push-pull mechanism, I think, is probably the most effective way to address discord. In other words, when you get to that point where the parties want a business divorce, and if they don't get a business divorce, they're probably going to force the company to implode. You want a mechanism, and this gives you a mechanism that eliminates some of the gamesmanship, games playing that can take place in a buyout, because somebody doesn't know whether they're buying or selling, so therefore they have to be reasonable. I suggest to you that the push-pull mechanism, the terms need to be in place. We'll get into that. And insurance may be used here as well. And so if you can talk your clients into buying a cash accumulation vehicle, the cash, as you know, will accumulate inside that policy on a tax-free basis and then can be borrowed and when a trigger event comes up, and perhaps provide then a mechanism to begin the process. Covenants and most common clauses. Well, non-competes by the selling shareholder. If you're going to buy somebody out, you want that somebody to agree not to compete with you as the buyer. And that's a very common clause. And we'll talk about that when we get into the clauses that you should put into your agreements, or at least be cognizant of the fact that they should be in those agreements. I clearly think that if the entity is going to be the maker on the note and the buyer, that the personal guarantee of the remaining shareholders or members is essential. Because if you were borrowing money from the bank and you're a small, closely held business, the bank would want the personal guarantees of the owners. Same thing here. This decedent's estate's the seller. They're financing the transaction. They should be guaranteed. Occasionally, you will get people that don't want to guarantee the whole thing. That's called joint and survivor. In other words, if there's 3 surviving members, they're all on the hook for 100%. Occasionally, when somebody gets into that kind of a negotiation, they say, I tell you what, I'll guarantee 50%. So you now have 150% guaranteed versus 300% guaranteed. It's a give it and a take, a yin and a yang. If I'm representing the buyers, I might want to limit the guarantee, particularly if I'm a minority shareholder. And if I'm representing the decedent's estate, I want joint and survivor. So it depends on which side of the equation you are. And a look forward provision whereby if the entity is sold within a window of time, let's say 3 years to 5 years, at a significant premium over what the deceased shareholder member of the family received, then they will participate, or their estate will participate in that windfall profit, if in fact it is. Certain limitations should be on, I think, the ability of the survivors to drain the entity, because they have to keep the money in the entity, because if the entity doesn't survive, the promissory note to the deceased estate doesn't get paid, and the family doesn't get what they should get. Therefore, we want to make sure that we give the surviving members as much incentive to pay off the deceased member's estate as quickly as possible. This would include financial statements and tax returns. And you have to be aware of the fact that if in fact the entity is the maker, is the buyer / a redemption transaction, that note will probably have to be subordinated to the primary lender of the operating entity, which is another reason why you clearly want to go ahead and have the surviving members personally guarantee that obligation. And finally, there should be an acceleration. If they sell the company and get paid by a third party, they have to use some portion of those proceeds to pay off the decedent's note. That should be an essential part of any agreement. The non-compete, anti-piracy. Non-compete says I have to stay out of the financial planning industry for the next 3 years. An anti-piracy policy says, or rather, clause, contract says, I can't call on the customers of my employer that I called on when I was employed by that employer. I can stay in the financial planning industry. I just can't try to steal, milk those clients, have those clients transfer their business to me. The same thing with employees. I can't hire the employees that I worked with because it will destroy my former employer's business if I take that business with me. Now, the example I also use is this. I use this with accounting firms often. If in fact you tell that client that they can't use the CPA Jim Aussem they've been using for the last 15 years because he has now left your employ and he's subject to a non-compete, my experience is that client is going to be upset that they can't use that CPA they've been using for 15 years. And if they can't use them, they're not going to use you either. So they're simply going to move the business to a third party, and both Jim Aussem, the CPA who left, Jim Aussem's employer, lose the client. That's a bad result. So what we suggest is that if Jim Aussem wants to take that book of business or some portion of it, he can take it, but he has to pay me for it. So over the next 3 years, perhaps the first year, my former employer gets 100% of the fees after a reasonable amount of expense. The second year, 60%, and the third year, perhaps 40 or 20%. So you transition those relationships, but if I was the employer, I get paid, and the employee can take those relationships, but they have to pay for them. They can't steal them, they can't take them for free. Works well, think about that. Works well, I think, in professional service environments, because having the relationship with the client is the whole value, right? If that client doesn't stick with you, doesn't remain with you, the value is not going to be there. Whereas if the value transfers to the next generation, if you will, because they know, like, and trust them, because they've worked with them for 15 years, the next generation can afford to pay you, the senior generation, for what you've created. Usually, these agreements, if done correctly, should please both the buyer and the seller, bring out more things. Proportionate or joint survivorship, we talked about that, and joint and several obligations on a personal guarantee. So. Clawbacks, look forward, they're used interchangeably. And again, you talk about if I sell the business after I buy you out, presumably you sold me the business because you're a member of my family at less than you would sell it to an unrelated third party. And if you do, in fact, sell the business to that unrelated third party within, let's say, 3 years, maybe I participate in that sale on a declining scale basis. The first year, I get 100% of what I would have gotten. The second year, I get 66 2/3 of what I would have gotten. And if you sell it in the third year, I get 33 1/3%. And after that, I don't participate. Obviously, it'd be 5 years. I've done them in family transactions where they're 10 years. I think that's too long, frankly. A 10-year transaction is not something that somebody was anticipating when they bought out their brother or sister or even their parents. And then we'll see as we get into the actual language, when you do this kind of thing, you have to define proceeds, because in most cases, in closely held small businesses, which is my area of activity, a significant portion of what could be the sale price of an entity sale is disguised as consulting and non-compete payments because it's tax deductible to the buyer. It's ordinary income to the seller, but it's tax deductible to the buyer, and therefore is it really consulting and non-compete, or is it disguised proceeds on which there should be a clawback? That's why it's important. That's why we have it here. That's what we'll talk about when we get into the section that deals with language. Salary bonus, I think we should limit the salaries of the surviving members. In other words, whatever they were receiving at the time of your client's death, perhaps adjusted for inflation, so that they are motivated to pay off the deceased member's estate. And sometimes what we do is we go ahead and say if they want to pay themselves a bonus above and beyond normal salary and other increases based on the cost of living, we have that bonus also paid as a dollar for dollar reduction of the principal obligation. So they work hand in hand. That's a pretty good motivation, because the sooner they get that note paid off, the sooner they are free to pay themselves as much money as they choose. I certainly think to verify that kind of thing and to make sure that your client, the seller's estate, trust, family, knows what's going on, they have to have access to the financial statements, tax returns, so they can be assured that the company is doing well. They can also be assured that the salaries are not excessive, that they're not draining the thing. There's got to be the ability to verify compliance. And certainly if you're a surviving member of the entity, you want confidentiality, so you should be motivated to pay off the deceased member's family as soon as possible. Keep in mind, there may be subordination. We talked about that. Certainly, if it's a redemption, it's going to take place. There's collateral. If the seller is given collateral of any kind, that collateral, in most cases, I would say 99.9% of the cases, is going to be second in line to the primary lender of that entity. So it's going to be subordinated. And a subordination agreement basically takes away the legal remedies of the seller because they can't exercise any of those legal remedies without the bank, the primary lender's permission. Certainly, if the business is sold, that note should be accelerated. We talked about that, and it should clearly be in the agreement because ultimately the only real collateral for the entity purchase or redemption is in fact the business. So that should be in there, and we want that note accelerated. So I think what I want to do now is I'm going to walk you through these provisions, and these provisions drag along minority, supermajority issues, capital calls, employment status. These are all part of what I want to discuss with you at greater length today. So I think I'm going to move that to the next thing on my screen. Okay, and let's go ahead and show you that. Okay, I hope you can all see that. And Shannon and or Patty, if you can't see that, please let me know. But it's alternative common clauses for buy-sell agreements.
We see it. Thank you.
You can see it?
Yes.
Perfect. Thank you. And so this is not done as a PowerPoint because it doesn't really lend itself to that. But as Shannon said, you could have this. This particular version is the same one you have. It's just that I redlined it. I redlined it because that's simply a reminder to me of the important clauses in here that I want to cover with you. And it's not necessarily because there's something wrong. Now, I practice law for a living, and these particular provisions are samples. And whether you're an accountant, a CFP, a COU, and a practicing attorney or whatever, I am not telling you that you can use these clauses as is. You take the responsibility of using them. These are from my practice. They've been used in specific instances. Transactional facts drive which one you use. I will try to explore some of those things with you, but I am putting up a disclaimer, folks. I'm not in the business of selling, and this is not a selling of form books, okay? I am simply giving you some clauses. These clauses that I use routinely are part of usually a close corporation agreement, an operator agreement of a limited liability company, or even a partnership agreement. They are buy-sell provisions. We don't use buy-sell standalone agreements very often any longer. They exist in some cases. They're necessary. Sometimes we restate old ones, but generally we want to put a little bit more in there, and we can do that through an operated agreement or a close corporation agreement, and we can adjust a standalone buy-sell. All right, three appraiser method. It is important to understand that you can't look up the value of a privately held business in the Wall Street Journal. But the value of the privately held business drives the lifetime buyouts, the disability buyouts. It also drives what's going to happen at the time of a person's death. Now, the alternatives, besides an appraisal, is a formula or a stipulation. And the trouble with formulas are, for example, the formula that you used in 2006 for a real estate business probably didn't work in 2009 because the economy went south and it really impacted it. So I don't like formulas because formulas also are not tested, and make sure the formula that was derived in 2006 still works in 2021. There's lots of things that can be done to manipulate a formula, and to really make it work, you've got to build in a lot of detail. For example, the salaries and the limitations on rent, things like that, that might otherwise determine the EBITDA has to be very complex. And stipulation of value is used because everybody says that the person who knows best what this business is worth are the people that own it. But if your clients are like mine, they'll stipulate the value the day the agreement is written and signed, and they won't stipulate it again until somebody dies, and that could be 3 years later, that could be 10 or 12 years later, and that stipulated value that is 12 years old is probably outdated. So what I call stale. So what I do is I tell clients, let's go ahead and use the stipulation for value, and that's what this language says. But if in fact a trigger event, that's what this language says, trigger event occurs within 24 to 36 months of the last stipulation, then we're going to throw the stipulation out because the stipulation is stale. If the stipulation is stale, we can use a formula, which I don't like, okay? Or we can use a three appraisal method. What happens with the three appraisal method, I give you some of the language there that go ahead and provides that a specific language that I use in agreements. If two or more, and it could be one or three, has passed since the date of a trigger event, and obviously you've got to have the trigger events defined in your document, you know, their death, disability, etc., and it could be termination of employment. A lot of different trigger events, and we'll get into that. Then that would trigger an alternative to the stipulation because the stipulation isn't up to date. So therefore, we're going to have, if the parties can't agree on the value, we have the entity usually hire an appraiser, and the appraiser comes up with their value. Then the surviving or the deceased or disabled shareholder can in fact accept that value. If in fact they do not accept that value, okay, then the deceased or disabled shareholder, or in fact disgruntled shareholder or terminated shareholder, would have their own appraisal done. And then if those two appraisals, that's the small variance, if those two appraisals are within 20% of each other, the language is a little tricky, you know, between the two per unit values that not exceed 20% of their average. Trust me, that works. Then that becomes the value. You're done. The appraisers have done it for you. You don't have anything further to fight about. If in fact there's a large variance, in other words, if they aren't within 20% of each other, then a third appraiser is appointed. Now, one of the problems you sometimes see with the three appraisal method, we tried to address that with this language that's in red, okay, that says, and it's not unusual to have somebody tell their appraiser, do not agree on a third appraiser, because that'll keep pressure on them to accept our value or to work something out. Well, we usually use a clause that says, if the two appraisers cannot agree on a third appraiser within some period of time, let's say 10 days, then in Cleveland, Ohio, we use the Weatherhead School of Management, case Western Reserve University, or someone who was qualified to not do the appraisal, but to pick a qualified appraiser, so that we in fact get an appraiser. And then you've got two approaches. You either use the third appraisal as your value, or you take the third appraisal and you average it with the one that is closest to. That's the language on your screen. That's Romanet I, Romanet number 1. Okay. So this is the language that I really prefer in buy-sell agreements, because it allows you to use the expertise of a valuation expert who should understand the industry that you are seeking an appraisal in, and also understands the exigencies, the surrounding circumstances, if you will, of that particular entity, the economy in general, etc. And therefore they can apply that. And it may sound like it's expensive, but battling and attorney's fees are more expensive. And this methodology, three appraisal method, eliminates those kinds of problems. The fees obviously should be paid by the members, right? In other words, the entity pays for the first one usually, the survivor or the deceased estate pays for the second, and if you need a third, it's split equal distance by the parties. All right, drag along provision. I realized last time I did this, a lot of people were not familiar with that provision. That particular provision makes it easy for the majority to sell the enterprise. The reason it's important is most buyers, particularly private equity type buyers and others, don't want minority shareholders. They want to buy the entire entity. And if in fact your client owns 66 2/3% of the entity, and the buyer wants to buy the whole thing, the other owners, the 33 1/3%, might have a super majority condition in the operating agreement or the close corporation agreement or even the buy-sell agreement that says you need 70% approval to sell the company. And all of a sudden the majority owner can't sell the company to the best and highest use buyer because they can't deliver 100% of the shares. Drag along provision eliminates that. Okay, what the drag along provision says that if the board and the shareholders, obviously the majority, approves a sale of the entire company, then they will consent. They being in my example, the 30% minority will consent to the transaction, even though they're not happy with it. They've agreed in advance to consent to it. They've waived the rights that they have under the Ohio Revised Code or similar states that says you owning 66 2/3% could theoretically sell the company, but the price is way too low, and so we're going to dissent to the actual price. All of that goes away with the drag along, where the owner of the company, the majority owner, and if you're representing the majority owner, you probably want to make sure that you have a drag along provision in your buy, sell, or similar agreement where the governance of that entity is described so that they can sell the company. That's how the majority owners and ultimately the minority owners will get the highest and best price. And we're going to see later on too, where I think having first right of refusal is a real negative in these kinds of plannings. So the key here is Romanet I in red on my screen, and hopefully you see it, is that the minority shareholder is getting the identical terms that the majority owner is getting. In other words, the minority shareholder or membership unit holder is not taking a discount because they don't have control. They're not getting paid different terms. They don't have longer installments. Everything has to be identical to what the majority is getting. That's why it's a reasonable approach. There is consideration for that. And if the class shares are different, again, they get the same treatment that they would get if they were part of the majority. Okay? And if you're dealing with companies that have some public securities issues, you may want to address that and seek some expertise on that as well. And I've given you some language as at least a tip off to what might be something you need to think about. Sale of the company tag along rights. A tag along is just the opposite. Okay, the tag along is saying that somebody is willing to buy controlling interest. So maybe a private equity company comes along and says, Jim, you own 70% of the company. Right now, it's a little too expensive for us to buy 100%, but we'd like to buy your 70% because we want to control the company. Thank you very much. And all of a sudden, I'm saying, great, I am happy to sell you 70% to take control of the company. Well, the minority members of that entity want to get the economic benefits that I'm getting. So they have the right to go ahead and raise their hand, basically, and say, we want to participate in this sale proportionately. So they would get 30% of what I would be getting because they are tagging along. And that 30% would be at the same terms, conditions, no discounts, installments, cash, down payment, whatever the controlling shareholder is getting, the tag along would get as well. And as I said, I think in the italicized description of sale of company tag along rights, anytime the majority asks for a drag along, the minority, if properly represented, is going to ask for a tag along because they want, it's a quid pro quo. If you want to drag along, I want to tag along. I want to make sure that I can take some money off the table, that I can have a liquidity event if you're going to have a liquidity event. So it works very, very well. Now, the tag along is voluntary in the sense that some of the minority shareholders don't have to sell. If they want to retain their proportionate share of the business, they can do that and not sell. But in most cases, my experience is if there is a viable transaction that motivates the majority owner to sell, it motivates the minority owners to take a piece of the deal, if you will. Change of control. This is a definition that impacts a lot of transactions. It impacts buyouts, what we call state put bonuses, awards under phantom stock. A typical phantom stock plan says that your plan benefits are going to accrue over 5 years, let's say, 20% a year vested. But if in fact I sell the company before you're fully vested, that change of control event triggers vesting and you become 100% vested. It's also necessary in terms of tag along and drag along triggers. We have to know when something is changing that would trigger that event. And that's quite often a sale of substantially all the company's business or operations to an unrelated third party. That's a classic definition. There are nuances to that. Okay, but keep in mind, some people forget about the fact that most sales in small, closely held businesses are a sale of assets. Okay, So you can't just use a sale of substantially all the stock. You've got to use the sale of substantially all the company's business or operations, assets, a merger. Sometimes mergers are done with the surviving entity being the merger partner. For tax reasons, it's done that way because a merger can be a tax-free transaction. Then with a cash out of the members of the merging entity that did not want to continue. So there's lots of different ways, but that would trigger these buyout provisions and the way things are done. Supermajority list. Here we're talking about my list of things whereby the tail, in some cases, wags the dog. We had talked about the fact that if I own 66 2/3% of the stock of a corporation in the state of Ohio, I have sufficient voting power to sell the assets. Okay? But if in fact the 33 1/3% owners are represented by counsel, and in the space of developing the buy-sell agreement, or in the discussions and negotiation of the close corporation agreement or operating agreement for a LLC, they want to make sure that the 66 2/3% owner can't run roughshod over them and force things down their throat. They therefore ask for this supermajority list of actions that require more than just 66 2/3% perhaps, and define that. And so it could be more, it could be less based on the facts, because in close corporation agreements and operating agreements, what you're doing is you're writing the rules. In Ohio, for example, the operating agreement for LLC says, and the statute says, these are the rules unless otherwise provided in the operating agreement. So you're going to override those rules in the operating agreement and make it fit your facts. The close corporation statute in the state of Ohio says you basically don't use the statutory framework, because you're going to write your rules vis-a-vis what percentages are necessary to approve a sale, to do this, to do that. You're going to do that by agreement, not by statute, not by legislation. So when you're negotiating one of these, you have to know what triggers a supermajority and what percentage that would be. And then once you decide that, what does it impact? Well, clearly, and we talked about this with the drag along and the tag along and that sort of thing, usually the number one supermajority issue is the sale or disposal of substantially all of the assets. Now, if you are representing the majority owner, you probably don't want that to be a supermajority issue. You want to give them a drag along right and a tag along right, so they'll obtain the same economic benefit, but you don't want that 30% minority or 66 1/3% minority being able to kill a deal. Okay? So, like I say, depending on what side of the negotiating fence you're on, it may be a good idea to have supermajority issues, and it may be a disaster. Admission of new members or shareholders, that's pretty typical. Borrowing of funds, particularly borrowing of funds that require the individual members to personally guarantee. Let me give you a classic example. You're the older member, and your younger members go to the bank and want to borrow a boatload of money to expand the business. Well, you have the net worth. They don't. The bank's going to want you to post your net worth to have your younger members borrow the money. You probably don't want to be in that position, so you want the ability to kill that if necessary. You don't have to exercise it, but you may want the ability to kill it if necessary. So think about that. Additional capital contributions. If in fact you're in business with a very wealthy person, and that person says, well, we need some additional capital, I'll put it up, and you can't put it up, you're going to be diluted. All of a sudden you're going to be going from 33 1/3% owner to a 20% owner. Or should that in fact be subject to supermajority issue? And then there's alternatives, we'll get into those, that can provide a way to avoid that. Defer or waive the receipt of tax amount distributions, we'll get into that. But if you have a pass-through entity, that entity is going to pass through its taxable income to the members or shareholders or members taxed as an S corporation, whether or not they leave the money in the entity. So you want to try to force out at least sufficient cash to pay your taxes. If not, again, that less endowed personal net worth person is going to be at the hands of the more wealthy liquid partner. Any amendment to the agreement, that's critical. In other words, you enter into an agreement, everybody's agreed to a supermajority issues, drag along, tag along, and then all of a sudden the majority can change it unilaterally. If you want to be in that position, you got to make sure that there are limits on what can be done. And then distributions in excess of the tax amount. Alternative, we get into that same language, 20%, 66%. Okay? And we talk about not doing any provision of the LLC Act. And again, you're writing how this thing will work. Okay? Declaration of payment of dividends, that sort of thing. I don't want to, and payment of annual salary, again, depending on what the structure of this transaction is. The wages have to be approved by the majority, so family members. Payment of bonuses, same thing. We've had a couple of situations where the majority was paying themselves huge bonuses. In fact, the minority would have to approve those bonuses to be paid. So it gives the majority or minority, depending on who your client is, some control over their destiny and how these things are done. I'm not going to go through all of these. I think Romanet I there, I simply took this out of an agreement. Frankly, I think $5,000 for capital expenditures is way too low to give them the supermajority approval. I think it should be a much higher figure. Now, obviously, it's driven by the size of the business as well. This was a reasonably small business. All right, transactions with affiliates. You all know, or you should, that it is quite often appropriate for the owner of a business to own the real estate for that business outside of the operating entity, and then lease the real estate, the operating headquarters back to the operating entity, because the money comes out of the operating entity as tax deductible to the operating entity and goes into the owner's pocket as sheltered by depreciation cash flow. So $100,000 a year of rent might only be $60,000 a year of taxable income because of a non-cash deduction of depreciation. And there are other examples where that might take place. So you want to go ahead and make sure that you've waived any conflicts of interest that might exist vis-a-vis that in most of these agreements. Insurance and disability, well, clearly, I think you can, in fact, buy that insurance, even if it's not specifically mentioned in the agreement. But I would suggest to you that it be mentioned in the agreement so that you know it's there. And it also, the language I put there is shall or may. Clearly, there's a difference. Shall means you're going to have to buy life insurance. You're going to have to buy disability insurance. May says we'll do it if it makes economic sense, etc. Certainly, I think it is something you should explore with your clients. And then the language that I've used there on the disability, you notice I actually put in language that suggests how much disability insurance you might actually purchase based on historical distributions or salary and that sort of a thing. So, because when you're buying disability insurance, you have to have a starting point. We know that life insurance is driven by the valuation mechanism for the company. Disability is a different mechanism. And then at some point too, you have a situation where there may be the disability insurance is offset against the amount ultimately paid for the stock of the disabled member. Additional capital contributions. This is where it gets interesting, because if your client is the very wealthy client, they can make a capital call. If the other parties can't keep up with them, the other parties could in fact be diluted. We talked about in the supermajority issues, sometimes that kind of a capital call is treated as a supermajority issue. So we would prevent dilution of the minority less endowed member. And sometimes the alternative is in lieu of a capital contribution, that the well-heeled member of the LLC or S corporation, whatever you want to call it, could make loans to the entity. And if they make loans to the entity, usually, and you have to be careful with an S corporation because you could create a second class of stock, much easier to do with a limited liability company, taxed as a partnership, that the people that make the loans get distributions ahead of the people that don't make the loans. So if I loan $100,000, I may in fact get a bonus that says, all right, I'm going to get a 5% interest rate, and I'm going to get the first dollar of cash flow from this entity until my $100,000 loan is paid before the members of the LLC who cannot afford to make the capital contribution are paid. That's the way often to do it, but it usually avoids dilution. Now, I think I have 10 minutes to go. Let me see if I can get into some of these final ones. And again, I'm happy to answer questions for some of you. Here's what we talk about in terms of distributions. If you have an entity that is a pass-through entity, S corporations, partnership, etc., you should clearly have a tax distribution. That's the tax amount distributions. And then other distributions should be called for, and then liquidating distributions. So that has to be addressed. Transfers to third parties. This makes me crazy. This is a typical provision you see in buy-sell agreements. And what it basically says is, if I want to sell my stock and I find somebody who wants to buy my stock, then I have to first offer it back to the company or the other shareholders at the lower of what the third party is willing to pay for my stock or what the agreement says vis-a-vis the valuation. Theoretically, that's a nice concept. The problem is, if the only way to sell my stock is to find somebody who wants to buy my stock and make me an offer, and I own 20% of my stock, that's an illusory right. Because nobody's going to buy 20% of my stock, because it's not going to give them control over anything. And therefore, I effectively can't sell my stock to anyone. So therefore, I think when you go through these agreements, you're better off to have an actual mandatory right of sale. In other words, a put. If I want to leave, you're going to have to buy my stock. You may buy it at a discount. You may extend the number of installments. You may give me a lower interest rate. You may do a whole bunch of things, make me sign a non-compete. But at least I can dispose of my stock. This right of first refusal basically eliminates the effective ability to sell my stock, and then I have no other alternative. I don't like it, but I see it in agreements all the time. Each agreement in a buy-sell, each agreement in a closed corporation operating agreement should have non-compete, non-solicit, quote, anti-piracy provisions in it. And I do it by simply referencing it, then actually put an actual standalone agreement as an exhibit. Okay, is the way we do it. The 4Ds, they deal clearly. These are the issues that are the crux of buy-sell agreements. We talked about it. If a deceased member dies, they shall sell all, not less than all. They are obligated to sell. And the purchasers, the survivors, or the entity shall purchase all, not less than all. So this is a mandatory transaction. And I think that's what these agreements should provide. If somebody dies, they have to sell, and the other people have to buy. Now, the purchase price has to be determined. The purchase price could, in fact, be what we talked about. It could be the 3 appraiser method. It could be a formula. It could be a stipulation. So the purchase price has to be stated in the agreement, or how you arrive at the purchase price. I also suggest then that there be terms on the death. And in this particular instance, the terms that are used here in red, 10% down payment or 100% of the life insurance proceeds. You want to force that insurance out. You want to get it out of the entity. You want to get it out of the hands of the survivors and into the hands of the decedent's family, to the extent that the insurance is not adequate to pay the entire purchase price. Then the balance is paid in a note. That's the way that works. So you want to make sure that kind of language is in your agreement. Clearly, if it's an entity purchase, you want to make sure that the agreement provides that the surviving members will personally guarantee the obligations of the entity, and you can discuss or negotiate whether it's a joint and several or some kind of overlapping guarantee. Remuneration of surviving members, this goes back to what we talked about. This is the restriction on the members who are surviving, what they can do with the company while they are still obligated to pay the decedent's estate. I think this is necessary evil. Disability, we get into here. Again, a disability should be a purchase of the entire interest, not just a portion. And we try to define permanent disability. And ultimately, if they can't agree, then we have the person examined by a physician, and that physician's determination is binding on both the company and the disabled or allegedly disabled. And then we have mechanics on how that takes place. All right. And then let me get into one last section here before I take questions. Those are the, I give you a whole list of additional methods to motivate the remaining shareholders. But I want to get into this one last section before we go. We already talked about the throwback and the clawback. and we get into here where we define the proceeds and what that means, because quite often the proceeds, you can see in the red here, could be non-compete payments, consulting payments, etc. To the extent that I put exceed 10% of the conveyance proceeds. To me, that would clearly make it appear to be disguised purchase price. Sometimes somebody uses a fair market value of those services, which is more. Discord and removal, the key here is the ultimate strategy. If these people can't agree, then somebody sets the terms, and if they can't mediate it, then one person has to put, and the other person has to push. So I make an offer to sell you my stock for $1 million. We already know what the terms are. It's going to be paid over 5 years, applicable federal right. It's going to be personally guaranteed by you. You now have 30 days, 2 weeks to decide whether you're going to buy me out for $1 million or you're going to sell to me for $1 million. And that eliminates gamesmanship. That eliminates a lot of the things that make it difficult to dispose of a business. All right, I think 5 minutes left. I'm talking too much, of course. And if there are any questions, Shannon, I'd be happy to take some.
Okay, great. Yes, just a reminder to everyone, you can submit your questions through the questions tab on your control panel. We do have a couple questions. The first one is, do you always insist that a shareholder sell their stock once they cease employment?
Yes, a disgruntled shareholder, and if they cease employment, they're probably disgruntled, weren't doing a good job, who knows what. And they represent just a thorn, a wait for discord waiting to happen. So yes, I suggest that if it's a family or closely held business and they're no longer contributing to the bottom line, they should not be an owner.
Okay. And next question is, how do you enforce the restrictions placed on the owners of a business who still owe the deceased shareholder's family?
What we do, if we, those covenants we put in there that say that the surviving shareholder, or the deceased shareholder's family has the right to see the financial statements, the tax returns, and examine the books, and in fact, literally have their own CPAs come in and take a look at the business. So you can find out if they're paying themselves bonuses, if they're paying themselves excess disguised rent, if they're cooking the books, so to speak. So you want those covenants that are described in the paragraphs that I gave you. We didn't cover them because I ran out of time, but they're there.
Okay. Next question is, does a mandatory buy-sell all shares at death or disability become a risk if there is no way to acquire insurance? Meaning,
Yes.
then he followed up, meaning, do you step down from a mandatory buy-sell if insurance can't be acquired?
No, I think if insurance can't be acquired, and some of that language is in there, it talks about disability. If the normal promissory note on the agreement is 5 years, for example, if the deceased is uninsurable, or the insurance, because it was taken out so long ago, we can't add to it because they're uninsurable, then I would usually write it, 5 years becomes 7 or 8, and that's at the discretion of the buyers. In other words, if they can't fund it fully with insurance, they could at least extend the payments so that it doesn't impact the working capital of the operating entity. That's the way I do it, but I still think it should be mandatory.
Okay. At the moment, I'm just seeing one more question, which is, what can you do if a disabled member or shareholder refuses to be examined?
Well, that's why we have litigators, to be honest. But the only way you can do, the only way you can enforce any contractual covenant, if they don't do it voluntarily, is to sue them, haul them into court, just like a non-compete where you try to get an injunction or restraining order to prevent them from competing with you. What you're trying to do with a court order is get someone to submit to an examination by a qualified physician to tell whether or not that person is disabled. It's expensive, it's troubling, it's acrimonious, but that is the only way to do it. You'd have to sue them.
Okay. And that looks like it was the last question. So that takes us to the top of the hour, so we can conclude at this point. So a reminder to our attendees, when you log out, an evaluation will appear if you take a moment to complete that. We always appreciate your feedback. A reminder that the recording of the webinar will be available in a day or two by logging into your FSP Go account. Should you want to review any portion of this webinar again. And we hope you join us on June 22nd when Jim will be back to discuss insurance funding and alternatives to buy-sell planning. And on behalf of the Society of FSP and FSP Go, thank you, Jim, for your presentation, and thank you all for your registration and participation today. And with that, the conference is adjourned. Thank you.
Thanks, Shannon.
Thank you.